When but I was waiting for. Ladies and gentlemen, I'm going to call to order this hearing of December 14th, 2023 in the matter of case file Z0123-23. This is a continued hearing from, I don't remember what date we continued it from. This is a continued hearing. But I don't think I did my introduction at the prior hearing, so I'm going to go ahead and do that now. My name is Joe Turner. I'm the county's hearings officer. My role as the hearings officer is to conduct public hearings and make decisions about certain land use matters in Clackamas County. In making those decisions, I am required to apply the county's existing laws. I am not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Board of Commissioners and Planning Commission to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. As a hearings officer, I'm to provide an unbiased decision maker. I believe I am unbiased with regard to the application before me today. I have not had any pre-hearing contact with any of the parties regarding the substance of the application. And I don't have any interest in the subject property or any of the surrounding properties. But anyone has the right to challenge my impartiality, to argue that I'm biased in one way or another. And you can do that when it's your opportunity to testify. Procedure will follow. I'll start by asking staff to summarize their staff report, copies of which are, and supplemental staff report. Do we have a supplemental for this one? Yes, we do.
Yes.
They'll summarize their staff reports, and then the applicant will have an opportunity to testify, to present their proposal and respond to the staff reports. If anyone else wants to testify in support of the application, they may do so. And then anybody who wants to testify in opposition or with questions or concerns. Once everyone has had an initial opportunity to testify, I will close the hearing for the purposes of the public. I will give staff and the applicant only an opportunity to respond to the testimony that was offered. If those responses include any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the hearing and announce what I'm going to do. Generally, I will issue a written decision within about 2 weeks after the close of the record. I'll send my decision to the county. The county will send it to parties of record. So anybody who testifies orally or in writing before the close of the record will be sure and receive a copy of my decision. If you decide you don't want to testify but like a copy of my decision, you can contact staff and ask to be put on the list to receive a copy. Excuse me, anyone with an interest in this application may offer relevant oral or written testimony. It's important that all parties make their best case to me. My decisions are final for purposes of the county, but may be appealed to the Land Use Board of Appeals, or LUBA. However, LUBA generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this application, you need to make sure it gets into the record before me. If you feel you need more time to prepare, you can ask me to hold the record open or continue the hearing. If I hold the record open, you'll have an opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we can come back and do this again at a later date. But if anybody wants me to hold the record open or continue the hearing, you must make that request before the close of the hearing today. However, state law requires that I also hold the record open for an additional week after it's closed to everyone else for the applicant alone to submit a final written argument without any new evidence. The applicant can waive that right if they choose. But if anybody else wants me to hold the record open or continue the hearing, as I noted, you must make that request before the close of the hearing today. In addition, my decision, I must issue a final written decision in this case within 150 days after the application was filed, subject to any extensions granted by the applicant, which I know they've extended it once already to accommodate this continuance. But there are some limits to how long I can continue or hold the record open. Then when it's your opportunity to testify, please begin your testimony by stating your name and your full mailing address. Please spell your last name so I get it right. And if you represent someone else, please say so. Also, your testimony should be relevant to the applicable approval criteria, which are set out in the staff report. Please don't repeat testimony offered by yourself or earlier witnesses. Repeating your testimony doesn't make your case any stronger. It's not a popularity contest. Whether everybody loves it or everybody hates it is not an issue I get to consider. The only issue before me is whether the application does or does not comply with the applicable approval criteria. Also, general testimony in support or in opposition. This is a great thing that should be approved. This is a terrible thing. It should be not denied. Isn't really helpful and is not really relevant. But if it's a terrible thing, it should be denied because it doesn't meet the standard. It's a great thing. It should be approved because it meets this standard is absolutely relevant, and I would love to hear that. That concludes my introduction. I will leave it to staff to summarize the technical issues of how you can participate in the hearing by raising your hand, etc. Ms. Lord?
Thank you. This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county's website later today. There is a designated time during the hearing when it will be open for public testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. For attendees on PC and iPad, you have a raise hand button on your Zoom bar, either at the top or bottom of your screen, depending on your device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all participants' cameras, not just the one who's speaking. Staff will call upon you when it is time for you to provide your testimony. Be sure to provide your name and mailing address when you begin. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, you can email your written testimony to myself at mlord@clackamas.us or mail it to the Clackamas County Planning and Zoning Division at 150 Beaver Creek Road, Oregon City, 97045. My contact email address is also available on the webpage where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer's written decision. If you do not wish to testify but would like to receive a copy of that decision, you must provide your email or standard mailing address to myself by email at mlord@clackamas.us or by entering it into the Zoom chat function during the hearing.
Okay, thank you. If you want to go ahead and summarize your staff report.
I will, thank you. So this is a hearing for a conditional use permit for a home occupation to host events. As you mentioned, it is continued. I believe it's continued from July 13th to today. My email address is at the bottom of the screen here for those of you who do want to provide written testimony or provide your mailing address to myself for a copy of the decision. My name is Melissa Lord, and I'm speaking on behalf of the Clackamas County Planning and Zoning Division on behalf of case file Z0123-23. This property is located on Beaver Creek Road, generally between Ridge Road and Jewel Road. The property itself is just under 20 acres in size and is located within the Ag Forest zoning district. The applicants propose to host events such as weddings for up to 150 guests, a maximum of 36 times per year. The events will take place in an approximately 3,000 square foot barn with an associated 1,400 square foot accessory structure with the asterisk that the applicants yesterday did submit an alternative plan, which is entered into the record as Exhibit 34, which would be for a new 2,400 square foot building to host the events rather than using the 3,000 square foot existing barn. The application includes a gravel parking area, which would accommodate up to 73 parking stalls. The 1,400 square foot proposed building would include permanent restrooms, a kitchen for preparation, and a flex space. So an office, a change room, or storage, things of that nature. The site currently includes a dwelling, a barn, and a 9-acre Christmas tree farm. I have a question mark here, and maybe we'll ask the applicants to just clarify that the Christmas tree farm is in fact still there. We did receive a public comment that the trees have been removed, and I'm not sure if that's just because of general harvest or if that's because the 9-acre tree farm is going away. There's also a 1-acre flower farm on the property as well. We have received some public comment related to this application. Themes on this application, themes on the comments on this application that were in opposition include whether the proposed use is compatible with the ag forest zoning districts or the uses allowed in the ag forest zoning district and the surrounding natural resource properties. And they also talk about the ability to continue farming or forestry operations nearby. Additionally, some comments received talk about traffic congestion or concerns of traffic safety due to the visibility, speed of vehicles, and types of vehicles traveling on Beaver Creek Road. The types of vehicles meaning more so farm vehicles, and I believe dump trucks was one of the concerns. I suppose that they're a little slower and a little bigger than your standard SUV. There were a number of personal reference letters that were received testifying that the applicants are hardworking folk, kind people, and of good character as well. Those have all been entered into the record. In response to some of the concerns related to the intersection safety or traffic safety, the Clackamas County Development Engineering Department did review this application. They reviewed Beaver Creek Road and noted that it does not have a posted speed limit and is therefore governed by what's called the basic rule, which would allow for speeds up to 55 miles per hour. Using that assessment, they've also evaluated the horizontal curve when you approach the site from the southwest and the advisory speed on that curve being 40 miles per hour. When they've evaluated these things against the county roadway standards, they've proposed that they've found that in order to have a safe site distance from the intersection of the subject property's driveway onto Beaver Creek Road, they would need to maintain a clear site distance of 555 feet to the southwest of the property and 610 feet to the northeast of the property. If this application is approved, staff recommends a conditional approval, ensuring that the site distance is being met. In terms of traffic generation, again, the Clackamas County Development Engineering Division reviewed the application. Beaver Creek Road is a rural minor arterial roadway and has an improved width of about 24 feet currently. The event center would generate more trips to and from the site. However, the average number of vehicle trips over the course of an entire year would be approximately the same as the average number of trips generated by either 1 or 2 single-family homes. Based on that, staff found that the existing improved roadway is suitable for the proposed event use. An amended staff recommendation or staff report was written. It was entered into the record as exhibit number 12 and speaks to an Oregon revised statute standard, which is applicable to this property. Because of the standard, which I'll go through in a bit more detail, staff is recommending denial of the application. So the ORS standard, section 215.760, talks about agricultural buildings that are used customarily provided in conjunction with farm use or forest use on properties zoned mixed farm forest, which in this case, this property is zoned ag forest, which is that equivalent. The ORS provision says that a person cannot convert an agricultural building to any other use. And agricultural building is defined in ORS 455.315, and I have a slide on that as well. But effectively, based on this ORS provision, the applicants are proposing to convert an existing ag building into their wedding event building, which based on subsection 2 of this ORS standard is not permitted. Going into more detail, agricultural building, we're referred to section ORS section 455 from that previous ORS standard, and agricultural building is defined to mean a structure located on a farm or forest operation and is used for storage, maintenance, or repair of farm or forestry machinery and equipment. There are a number of other points that describe what an agricultural building is in this section, but I picked this one out as the relevant description here. The building that is being proposed to be converted was constructed as an ag building, specifically for the purposes of storing farm equipment. Therefore, by definition, the building on site now that's being proposed to be used for the event center is an agricultural building. Furthermore, ORS section 455 specifically states what an agricultural building is not. So agricultural building does not mean a structure that's used for a purpose other than growing plants in which 10 or more people are present at any one time. It also says an agricultural building does not mean a structure used by the public. So by definition, using the ag building for an event center, which would be used by the public, which would be used by over 100 people at any one time, at any given time, the building itself would then become not an agricultural building by using it for this event center. So for those reasons, staff is recommending denial of the application based on the ORS provision not being allowed to convert the structure. Now, again, yesterday, the applicant team and the applicant's representative did supply staff with an updated application request with an alternative plan to perhaps build a new building. Given the timeline of these events, staff has not yet reviewed this proposal. And so my PowerPoint, my presentation was based on earlier yesterday morning before that subsequent plan had been provided. So that's all I've prepared for you at this time.
Okay, thank you. Where are we on the 150-day clock?
We are, give me one moment.
Yep, no problem.
July 13th was day 58 of the 150-day clock. The applicant did toll the clock, and so I suppose today is day 59.
Okay, great. On the ag building issue you were just talking about, it's my understanding that an ag building is defined as such because it was constructed without a building permit. If they get an after-the-fact building permit, wouldn't that make it no longer an agricultural building, the existing building no longer an agricultural building, and then could be used?
Yeah, it's an interesting question. Our what am I looking for?
Our attorney.
Our attorney, thank
counsel.
you. I'm like, our legal staff. But
I know, I blanked out
this.
like
Oh
that
my
before
goodness.
too.
Our attorney did review that and the county consulted with the state building officials, our attorney and counsel, and did determine that there is no correlation between this particular ORS section and whether or not you got a building permit. That section does allow you to construct buildings that are exempt from meeting the standards of the Oregon Structural Specialty Code, but whether or not you can convert the use, I don't believe is associated with whether or not you constructed the building without meeting the Oregon Structural Specialty Code. Lindsay Nesbitt,
Yeah.
planning manager, would like to jump in.
Yeah. So hearings officer, Mr. Turner, we asked that
Can I
specific.
get your name, Mr. Nesbitt?
What's that? Oh,
Can you
sorry.
state your name?
Oh, sorry. Mel had given me the shout out.
Yeah.
Lindsay Nesbitt, planning manager, Clackamas County.
Thank you.
County council had specifically asked your question. Well, can't they just get a change of occupancy and convert it to a different type of use? And the response back to that was no. It was the way the rule is written. The way the rule's written, there's just no way to convert an ag building to a different use.
And the response was from the state building official?
It was, Mel, do you know? I don't know specifically. I'd have to look at the memo that was prepared, but I believe it worked in conjunction with the state building official.
Correct. That's my understanding.
Can you repeat what was the understanding?
That county council worked in conjunction with the state building official when examining this question in this issue.
Okay, I thought you said the county council asked somebody, so it was probably, but together they concluded that once it's an ag building, it's an ag building. You can't change it back.
Mm-hmm.
Is in a nutshell. Okay.
Yeah, and if I believe that there is written correspondence on this, and if I can, if there is,
yeah, I'd love to see it.
If the record's left open, we can enter it into the record.
I'd love to see that. Okay. Ms. Lord, do you have the site plan? Because I have a question about, I think the north arrow is off and that was throwing me off.
It is off. Let me share my screen again. The north arrow is facing the wrong direction, so you're correct.
Okay, that's what I thought. It took me a minute to figure
I took it out of my PowerPoint just to clear things up. The site itself is slightly skewed, with north, I believe, being ever so slightly to the left of our page, but generally this is pretty close to north being at the top of the page.
Okay. The site plan that I've got shows north being
at the bottom of the page.
Bottom
No,
right.
you're correct. That site plan has the north arrow facing the wrong direction.
Okay. And on that similar issue, I think it's called the dressing building on the site plan, the northern building. That's the new additional building that they proposed, not the new replacement barn, so to speak. It looks like the elevation designations are off there too. It says the east side elevation is a long frontage. The west side elevation is a short frontage, so that doesn't work. So some of those are off. It's not a critical issue. I can figure it out, but I just wanted to flag that if the applicant wants to correct that, if we hold the record open. I'm just kind of going through my question. Most of these are for the applicant, and we talked about that one. I know that we noted this was originally continued to January 11th of 2024. I understand the applicant requested a hearing sooner, and I assume the county sent out revised notice of that. Yes.
Yes, that's correct.
Okay, thanks. I see you nodding. I just want to make sure it's on the record. The Christmas tree issue we asked the applicant about. On page 17 and 18, and also page 28, or sorry, that's the Christmas tree issue we just talked. Also on page 17 and 18, it said the staff report notes 36 events and a maximum of 150 guests, which I think is what the applicant has proposed. But then condition approval 9 says 24 events and 100 guests. And are the transportation findings based on the application or the condition as conditioned?
So I think that condition is likely just a typographical error.
Okay. You weren't intending to limit it below what the applicant is.
Correct. Thank you.
Okay. And I'm just writing a note if people can't see what I'm doing, so I want to make. Same with Condition 9 goes on to say no more than 5 events per week. And so I'm assuming that's also a typo. Wait a minute. That may be from the code. Let me. Okay, I think let me get to the condition language because I'm reading what I've written down. Condition 9 says no more than 1 event per day throughout the entire year, no more than 5 events per week, period. During the months of November through March, no more than 5 events shall be allowed per week. I don't know what the purpose of that second sentence is because the first sentence limits it to no more than 5 per week. Is that also a typo that during, I guess it would be April through October, more events are allowed per week?
The code allows for no more than 7 events per week through
That's
the
what I
months of
thought.
April through October.
Okay. So that was, was condition 9 a typo? Should it say 7?
That's correct. Yep.
Okay.
Well, condition 9 says through the months of November through March, no more than 5 events would be allowed per week.
Right, but the sentence before that also says no more than 1 per year. I mean, 1 per day throughout the entire year and no more than 7 events per
Okay.
week. I assume that's supposed to, 5 events is what it says. I changed it to 7. I
I see,
assume it's
yep.
supposed to say 7 between April and October.
Correct.
Okay. Thank you.
Mhm.
On page 19 of the staff report. It says there's insufficient information provided to know if the lighting criterion is met or not. So I'm wondering why they're recommending approval without that evidence.
On page, what, sorry, you said
19,
19?
the finding, first paragraph, the last sentence of the first paragraph.
I might have a different page number 19. I'm sorry.
Could be. This is it's number 3, ZDO section 1000 development standards. B section 1005 relates to design of the buildings and the site, and then the finding below that.
Oh, I see.
And the last sentence of that paragraph, that finding.
I would have to look at that and maybe get back to you.
Okay. On pages 22 and 23, at the bottom of page 20, my page 22, it's section G 100702 parentheses D, the finding. Says it's responding to neighbors concerned about people turning around in their driveways and other impacts. And the sentence says, in addition to recommending the applicant comply with clear sight distance, a discussion may be warranted at the hearing to consider additional temporary signage options posted on private property, indicating to motorists of the additional vehicles on the roadway on event days. It's the traffic issue rather than. Anyway, would those additional signs be allowed? Because that's my understanding the code limits it to 1 temporary sign. Or would those be considered directional signs? That I don't think they would be, but otherwise allowed under a different section of the code, just as general signage or a sign permit.
Well, I think there was some question as to whether or not based on traffic or speed that vehicles are traveling, if there was some agreement that they could make with the neighbor. One of the suggestions came up of, can you post a, turn here for event venue sign
Right.
further up the road, something like that. But of course, that wouldn't be on the subject property. Signs can't be in the right of way. So if a neighbor wanted to offer that.
Could the neighbor, if the neighbor were willing to do that, could the applicant would a permit be required? Could they get a permit? Would such a sign be allowed under the county code?
For an incidental sign, like a directional sign saying this, parking lot turning here, there wouldn't be a permit necessary,
Okay.
I don't believe.
On page 23, it talks about temporary signs. Exhibit 11, which is a letter from a neighbor and a photo, shows that what appears to be a permanent sign. And the code limits it to temporary. I think that's more of a question for the applicant. So
Yeah, the applicant has been operating events without permits, and so I think some of the public comment received talks about that, and so there is some, I think, differentiation between what's going on now and what they're asking to do within the limitations of the code.
Okay. On my page 24, it's section K, 1021 solid waste recyclable material collection. Similar issues, says there's insufficient information to determine whether this criterion can be met, but we're still recommending approval. So the same question there. And if you want to respond to that later, that's okay. The dressing building, I think is what they're calling it, has 4 restrooms, 2 showers, 2 dressing rooms, and a large kitchen. Is that normally associated with uses in agricultural forest zone, given the relatively small size of the site? I mean, I understand that restrooms are often allowed in agricultural or in accessory buildings in the county, but 4 restrooms, 2 showers, is that normally what's the text of the code? Normally associated with uses in the agricultural forest zone.
I think it would be. They've got over 10 acres of farmland on this property. Of course, that I posed the question earlier about the 9-acre tree farm, but it's not unusual for the county to approve buildings in resource zones such as ag forest with active farms with showers and multiple showers.
And the neighbors raised concerns with safety. Is there any crash data for the roads in the area? Somebody testified, submitted a letter about they'd responded to a certain number of accidents over the number of years.
The only crash test data that I've received has been from those public comments, so I haven't seen anything else. Our development engineering division, who did review the traffic safety, did not provide any comment about crash data.
Is that something the county can access, the crash data, to get it into the record?
Well, I can certainly put the question out there to our transportation folks.
Okay, thanks. If it's available, I'd like to hear about it. I think that was it. Yes, that's all the questions I had for staff. Thank you.
Thank you.
Excuse me. Mr. Hall?
Hearings Officer Turner, thank you for the opportunity to present to you today. My name is Damian Hall. I'm here on behalf of applicants Devin Peterson and Stacy Dalton. My address is 851 Southwest 6th Avenue, Suite 1500, Portland, Oregon, 97204. If you bear with me for one moment, I'd like to share my screen so you can see my presentation.
And before I forget, can you submit a copy of that to the record after the hearing? Just so it's an exhibit, so I can refer to it.
Absolutely. I think Melissa already has a copy, so.
Great.
Yeah. Can folks see a presentation? All right, fantastic. Okay, let me just step through this cover slide. We'll keep it short and sweet. You know, the crux of the matter is that the applicant agrees with the vast majority of what's in the initial staff report. You know, the applicant does not agree with the appended and new staff report and the interpretation of ORS 215. But you know, this has been an ongoing application and discussion with the county that the applicants have been having for well over a year, and we wanted to say that we really appreciate the work of the county planning department, and in particular Ms. Lord and how she's helped the applicant through this process. So just, a couple points of clarification about what is the proposal. And then I'll jump into, our thoughts on the conditions of approval and the state law standards. So the proposal to hold events in various configurations, I think, what we're looking at for improvements, there's an existing building, call it a barn. There's a proposed new building, that's the 2,400 square foot building. And if you can you see my cursor? It's if you can,
No.
okay. So if you see the
Oh, there it
barn,
is. Now I see it. It's just
all right. So this area,
in the wrong place.
yeah, no worries. This area right here, this rectangle, is approximately the area of where the new building would be proposed. And then what we're calling the dressing area or dressing building also would be new construction, is up here. And then there's parking here and then off screen to the south. And then a temporary tent concept. And I'll talk about sort of the different configurations and what specifically we're asking the hearings officer for here.
The temporary tent would be between the gravel parking area and the residence. Is that what you were pointing?
We
Options.
haven't necessarily said exactly what the temporary tent
Okay.
would be. Most likely it's probably in here.
I'm sorry. Every time you say in here, I look down. Tell me it's great. Thank you.
Sorry, due west of the barn.
Thanks.
Yeah. So, I just stepping through, the applicant would be very much satisfied with an approval to utilize the existing barn and build the dressing building. The tent and alternative building concept is only one that's come up lately as a result of an ongoing discussion about state law, which was, kind of the issue that came up just before the prior hearing that got continued, and we've been in a conversation about it, and I'll go into more detail on what we think are the more practical and correct interpretations of RS 215-760. So alternative one, which the applicant would prefer, is simply approve the events in the configuration in the initial application. So happening in the barn and the dressing room. However, because we've got a disagreement amongst legal experts about what is the meaning of this somewhat ambiguous state law, the applicant really would like to, have a way to continue to, hold and schedule events on their property, and is willing to invest if necessary to do so. When we think that the state law really shouldn't, kind of be a trap here. If everyone agrees that the use is allowed, how do we get from point A to point B? And if we really end up in a place where we think that, the existing building is not, for some reason is prohibited from ever receiving any additional land use approvals of any kind by that particular state law, then we would propose, that the hearings officer still approve the use in this alternative building, which is slightly smaller than the existing barn, but of a very similar character. Maybe wood exterior, similar character and architectural style, and typically provided with the uses that are allowed in the area. So that's what we're proposing. And then the temporary tent concept is simply, if we end up in the alternative building area or concept, that it will take a while to build a new building. Folks would like to get up and running and hold events in a tent during the pendency of construction of that new building. So let's talk about some specifics on the conditions of approval. we agree with everything from the initial staff report with the following exceptions. We propose removal of condition 13. I think it's the exact same as condition 4. It's just about, what temporary sign is allowed. If any, if staff sees a difference between those, by all means, we're glad to accommodate, but I just think they're the same. And then we'd request amending condition 9 to read as it's printed there. One of the issues, there's two issues essentially that we're trying to address here. One was holding consistent with that 150 person event attendee maximum, which I believe that was the proposal in the beginning, and the analysis was based on. However, there's also in there another number that we're proposing to change in that last sentence and have 52 events per year. So across the year, average 1 per week would be the maximum. And we think that is still in keeping with the character of the neighborhood. Holding one event average across the year per week does not change that character. It also, because of the nature of events, does not change the traffic related any risks. While on aggregate there might be more trips across a year, we still think it is comparable to 3 or 4 single family residences, and not something that creates a traffic risk or will lead to impacts to the road and things along those lines. Again, the same size events we're talking about. So on any given day that there's an event, the traffic profile remains the same. It's just averaging 1 event per week across the year. And then we'd have new conditional approval allowing utilization of temporary tents during construction of the new building. And I just spoke about that at length. So let's talk about the state law, the kind of point of departure that came up late in the game. We got through a lot of discussion with the county about, what is allowed, and got through completeness. And then, to be frank, I think the county hired a new attorney to help him out. And he, kind of had eagle eyes and spotted this state law on the eve of the prior hearing. And that's led to, the extension that about, my involvement, a number of, conversations with the county on the enforcement side of things as well. And here we find ourselves. To be clear, the applicant is simply trying to, play by the rules and find a viable way to create and permit an event venue. And I think that we have good interpretations here. And I want to, talk about sort of how we got to this spot before we're just diving into this kind of interpretive issue. So I've had a number of conversations and email correspondence with county council about this. What it boils down to is that there's not a controlling precedent. We're interpreting a state law. There was a Luma case that they took an off ramp. They kind of mentioned it, but nothing that happened that says, whether in this instance the county's interpretation is correct or the applicant's interpretation is correct. So, I think both the county and applicant kind of came to the conclusion that this is somewhat ambiguous. If the county's interpretation is correct, it's borderline. It's hard to say what the policy that's being implemented is by this statute. But let's talk about the specifics. Oh, also, if there is correspondence with any state building officials, I'd love to see that. That was not part of any communication that I had or that I was aware of. I'm not sure why they would be the expert on this particular statute. But to the extent they've weighed in, I would love to be responsive to that. So speaking about like, what does this statute mean? Let's take a trip down the legislative history. And, essentially there was a bill in 2012 that created RS 215-760, which gives the allowance for forest and ag related buildings without getting a building permit. And that allowance already existed in EFU and ag related lands. And this was the bill. A whole bunch of folks who own farm and, or pardon me, who own forest and ag farm forest land said, hey, we want the same treatment. And that's the crux of it. You've seen the statute. It's 2 sentences. It's not a complex thing. But it's got the second sentence, number 2, and that's what we're talking about. What does it mean when it says shall not convert one of these buildings to another use? And so that's kind of the crux of the matter. We went back and said, hey, who was talking about this at the legislature when they passed the bill? We were able to identify the committee hearing when this came up, and then the subsequent amendment. And there was a Senator, Ginny Burdick, at the time, who said, "Hey, why are there protections in here that stop people from, turning ag buildings into condos? Condominiums was the word that she used, and that's what she was concerned with." So members of the legislature were expressed concern that agricultural buildings would get illegally used to create residential development that otherwise would not be allowed on resource land. And section 2 is the edit, amendment, whatever you want to call it, that legislative council or DLCD or whomever penned that came up with to be responsive to that. So that was the problem set. Section 2 with the reference to cannot convert to another use was the answer. So really, are we saying that when a building approved under this section cannot be converted to another use? Are we saying that every single after 2012 farm or forest related building that gets built on forest or ag forest land, after it's built, you can never get a land use approval as relate to that building? It's frozen like an insect in amber. You can't pull permits on it. You can't, ever have more than 10 people that walk in the front door at the same time, or you are in violation of state law. So that's kind of where the county council came down on things. Needless to say, we believe that's overly broad. We think there's a better interpretation of that. We think that it's clear that the concerns that raised at the legislature were overlapping and in many ways redundant to the entire land use set of protections for farm and ag forest and forest lands. The answer to the question is, are there protections from stopping these buildings from turning into condominiums and residential uses? The answer was yes, there are many of them, as the hearings officer is well aware. And read properly, I don't believe that standard should be extended to say that an existing building is precluded from being receiving a land use approval for all of time, or receiving building permit approvals for all of time to be utilized for a use that is allowed under the existing zoning. And it's somewhat of a kind of practical common sense approach. The difficulty is take the alternative position and run it out to its logical conclusion, and you kind of get into some very impractical outcomes. And you'll see that documented in the addendum to the staff report, right? One of the options offered is, knock the building down and build a very similar building in the same place, and then you can have events in it. I'm not sure what policy objective that would be pursuing, nor am I familiar with any instance in the land use system, which I've admittedly not seen all of, but have seen a healthy chunk of, where that's the outcome, that a building can never get land use to be approved or put to another use. And I don't believe that simple sentence should be read at that broadly. So simply put, I believe that the application, the approval that we're asking for here today, once granted, that building will no longer be a build. There's alternative paths. That building either will no longer be a building authorized under ORS 215-760, because it'll be authorized in association with the event use, or what we're proposing simply is not a conversion. The vast majority of the time, this building will be without an event in it. We're talking about on average once a week throughout the course of the year. And during the balance of that time, if the building is free to be utilized for storage of materials and equipment related with the on-site farming. And so what we're it's specifically in response to some of the hearings officers questions about is farming ongoing on the site. The answer to that is yes. There is some amount of the site that is harvested on a seasonal basis. Christmas trees, you cut a bunch down every year. And the applicant is thinking of pivoting and utilizing some of the land for pumpkins in the coming seasons as well, and harvesting those type of things. But yes, it remains a working farm, and the building will be utilized in association with that working farm. So that's my take on ORS 215-760. Glad to answer any questions related to that, and then just the new going over real quick again what the requested approval is. We would request that we get approval to hold events in the existing building, but also approval to hold events in the new building with temporary tents prior to completion of the new building, and that those be alternate approvals so that if we go down a path and one of those becomes concerning or is not is appealed and all that type of stuff, that the applicant can pivot and basically proceed expeditiously to do what they want to do with their small business that they've invested their time and resource in establishing. That's it for the prepared presentation. I'd like to circle back and kind of answer to the best of my ability a number of the issues that were raised, I think, in response to the staff report. We're glad to go back and fix the kind of errors in the site plans about elevation and what cardinal direction is what.
Sure.
And
Appreciate
that
that.
type of thing.
Make it
Yeah,
easier to follow.
yeah, absolutely. There was a discussion about how many events per week. The applicant is fine with 5 events per week.
Okay.
The code has an allowance during certain months for more, but that doesn't seem consistent with what the applicant's looking at for a business model. We're really looking at that, averaging about 1 event per week across the year. There were some lighting related issues, and I believe looking at Z0123-23, we would be fine with a condition of approval requiring that all lighting be consistent with that standard. There's kind of 2 elements. There's a safety element, and then there's a avoiding light pollution element to that. So absolutely both of those things are of importance to the applicant. Let's talk a little bit about the temporary signage, because that came up in some of the in the opposition, and we'll be back in rebuttal, assuming some folks want to talk more about it, we can. But ultimately, there's the code that says you get 1 temporary sign. There's the ability to permit additional signs, and then it sounds like there's the ability to do kind of some sandwich board directional stuff, as well. And so what the applicant is attempting to do is clarify what is the right or the correct driveway, because they're essentially, depending on which way you're coming from, there's a fairly close driveway to their driveway, so you could mix it up that way. And then if you're coming from the other direction, I think from the east going west-ish, you can see, it's cleared and that's where their fields are. So you can see the venue, and there's a driveway before theirs, and that type of thing. So it's really, the problem set is how do we get folks to the venue without bothering the neighbors by turning around in their driveway and doing 3-point turns and that type of thing. And that's what the applicants are going for. I think some of the testimony indicated that neighbors were forced to put up signs and that type of thing. That was the applicants actually providing signs and being responsive to their neighbors saying, hey, can we do something so that folks don't turn around in our driveway? And so I think that the condition of approval as written covers it. The applicant's able to go and interface with the county and receive sign permits, and put up signs in addition to the temporary sign that needs to come up and come down and that type of thing. And so we'll figure out the best way to make sure that wayfinding is clear. I don't want to skip any issues that you raised, but we would agree with Mrs. Lord's assessment of the dressing structure and how it can be utilized, and is typically the type of structure that is utilized and provided for in the farm forest area, and that it can be utilized both for event purposes on a limited basis, but also for agriculture and folks who are doing the tree harvesting and that type of thing on the site. Looking at my notes, I believe that's all I've got. And Les Hearings Officer Turner did.
I've got a few more issues.
Yeah, go right ahead.
The lighting, you talked about, and I think if this is approved, a condition would definitely be warranted, but the photo from exhibit 11 from the neighbors shows some pretty bright lights, and it doesn't appear they're meeting standard at this point. But that required response. I just wanted to note that.
Yeah, let's talk about some of those photos, right? And so I don't have an aerial right here, but I know that the staff report had one, so you can visualize to the southwest of the property where the driveway is, and the property boundary, essentially.
Hang on just a second, I gotta turn. So south is where it should be. Okay, go ahead.
I could actually get this up and share again. Hold on one sec. All right, let me do a quick screen share here again, so that I don't have to paint a picture with words. We can actually look at the same thing. All right, I see the site boundary. Okay, so again, tricky because right now north is to the right.
On this photo?
I believe so, yeah. So this is Beaver Creek. North is over here, if you can see my cursor.
Yeah. Okay.
That's north. This is subject property. Where's
the existing residence?
Right, I believe right in here.
Okay, so it doesn't appear in this aerial. Was it recently constructed?
Somewhat. I believe we have in our testimony. It's a couple years old, but
okay.
This aerial was before then.
Okay, that makes sense. That's why I was confused by this photo, but that makes sense.
Yeah, and so long story short, those pictures appear to have been taken along this property line in this right here.
That was exhibit 11. Okay.
Exhibit 11. So number 1, some of those appear to have been taken from on the applicant's property. B number 2, there's no there's no home here. The home is on the adjacent property, is up in this area. And so those
so more directly west of the residence on the site.
directly west, more than 800 feet, and through thick tree growth, which has been maintained on the applicant's side of the property line, but has been somewhat cleared, as you can see on this aerial, but is filling back in nicely to the west on the applicant's property. So they've come, off their driveway, 5 foot kind of tramp towards the property line. In some of the pictures look like across the property line, and taking pictures up this way towards where the structures are.
Mhm.
So, I think that's kind of just an important factor in that. And then to the extent, lighting needs to be hooded or something along those lines. We're glad to comply with the condition of approval. And then I would also add that, photography is oftentimes, a
Sure.
picture doesn't come out the way that it is viewed with your eyes.
Yep.
Because
They just in the daytime photos, they appear to be, I think they're called Edison bulbs. They're just a clear glass and no shielding. So that's why I wondered about the meeting the standard. But I agree, it could be that particular issue could be addressed with a condition easily.
Yeah, and I mean, if we need to get into the specifics of light fixtures, we can. And the applicant is, dedicated to and invested in their business and complying with the code. And so, we absolutely would go down that path and ensure that we're not aiming any light where it should not go. However, I think that the approval standards, especially for the conditional use, really are about what, the receiving site being the adjacent home, and not, can you turn through a
I
field?
think the lighting standard just says it has to be shielded. It doesn't say anything about residences, so it has to be shielded, period. And
Yeah, absolutely. And I think we can, like I said, comply with that.
Okay.
1005 through a condition, but wanted to make sure we're covering our bases on the conditional use approval as well.
Okay.
Yeah.
The noise issue, the neighbors, Exhibit 11 also, they claim they measured noise up to 84 decibels. The code limit is 60 decibels. I can't remember it's an average, some language about average. It's my assumption that means, I think it's LEQ is what the noise engineers use, which is 50% of an hour, 30 minutes out of an hour. It can't exceed 60 decibels.
Yeah, absolutely. And we applicant has taken some readings and not been able to kind of replicate the outcome that's in Exhibit 11. However, it is hard to say what the conditions were for the reading that we see in Exhibit 11. And so I think we have a pretty clear standard that can be applied.
But I have to find that it's feasible to meet it. You're saying you're primarily indoors, but they have roll-up doors, a covered patio, and an outdoor ceremony area. Will the doors be open during events so noise can get out? Will there be amplified sound for the outdoor ceremonies? And will the covered patio be the events occurring on the covered patio, which isn't inside the building? Those are some things I'd like the applicant to address. I know sound, let me finish up here. I know sound diminishes with distance, but it's measured at the property line. I'm not sure what the distance to the property between the property line and the proposed event facility is. So that's something I would like some more evidence about from the applicant.
Absolutely.
And also,
go ahead.
Sorry, just one more on that noise issue. The code requires that events end by 10 p.m. And I wonder how the applicant proposes to comply with that. Will they stop the music by, for example, 9:30, stop drink service, make announcements as it gets closer, and then shut it off at 10, if they can address that, or you can.
Yeah, I mean, I believe that I can address it here first, with some statements, but I believe if I'm understanding correctly, what the hearings officer is requesting we would gladly hold the record open, provide you additional evidence as to the compliance with those criteria.
Okay, that'd be great.
Yeah, a couple things I'd point out, right? Like, yes,
Mhm.
I believe you're correct. The receiving spot for the sound standard is the property line or anywhere else on the property. But the closest property line is in a heavily wooded area.
Mhm.
So there's some, a couple 100 feet of trees that have sound attenuation qualities and act as a buffer and a screen for many of these impacts. Also, the amplified sound question, we can give you more details, but the idea is that there is a DJ booth and it is inside. I don't believe that, we're trying to say that you could have zero sound and amplified sound in a ceremony that partially is outdoors during a nice, during a nice time of the year. However, the kind of the dance floor and where the DJ is located are in a DJ booth that has, directional sound attenuating qualities, and it points towards the inside and not towards the neighbors. So we'll provide you additional detail on that and, evidence of how, we'll go out and play some songs and take some readings and do the whole thing.
And if those, the roll-up doors, if those are open, is that going to reduce the attenuation that you're going for? So just another issue. I'm sorry, you said something and I wanted to, if you could, you're arguing that those trees, obviously the trees provide some sound attenuation. I'm not sure how much. I thought I had heard in a different case entirely that vegetation doesn't provide as much attenuation as some people think, but I can't recall the specific case and anything else. So if you can provide me some support for how much attenuation those trees are likely to provide, if that's necessary. I mean, given the distance, if the sound is limited at the facility, wherever it's produced, if it's limited to X decibels, then given the attenuation over distance, it can't exceed 60 decibels at the property line. That's sufficient. You don't have to show me that the trees provide enough to reduce it. But if it doesn't, if you can't propose a decibel limit at the production area, I guess is the only term I can come up with.
Yeah,
well, sure that 60 decibels is met, then and you're relying on the trees. I'd like some evidence that those trees provide the attenuation needed.
absolutely. We'll provide the evidence needed to demonstrate the feasibility of compliance with that standard, and are, absolutely amenable to a condition of approval that requires ongoing compliance with that standard.
Am I correct? They're also proposing portable restrooms, and I don't see those on the site plan.
I just saw my client Stacy go like this.
And if you want to let her testify about that, that's great.
Because I don't know the answer offhand as to the specifics of portable restrooms.
Yeah.
Yeah.
The next question probably is more for her as well.
Okay.
I'm just trying to understand the site plan and what exactly is proposed where.
Yeah.
And I think you'll need to stop screen sharing for me to see her.
Apologies. I was taking
no problem.
notes.
And there's technology.
Okay. So do we want to just kick it over? Stacey, do you want to answer the questions about portable
That's
restrooms?
fine with me, and then we can come back to you if you want.
Okay, fantastic.
Ms. Dalton, is that correct?
Correct, Hearings Officer Turner, yes.
Thank you. Can you state your name and address for the record?
Yes, Stacy Dalton, address is 29335 South Beaver Creek Road, Malina, Oregon, 9704.
And are you proposing portable restrooms as well?
Correct.
Okay. And where are they planned to be located?
They are near the parking lot. I don't have.
I think you've got two parking lots, one that's south of the barn, one's kind of north and east. Is it? Which one?
I'm going to.
Sure. Oh,
Pardon?
sorry, I can share my screen of the site plan while you
Yeah,
talk
thank
about
you.
it, if that's helpful. Okay.
Thank you.
It's,
And
there we go.
And
So
then-
is it,
Excuse me. I didn't mean to say that only Stacy should answer the question. Sorry, Devin.
anybody,
Introduce
the
me.
rep-
Yeah,
applicant
Devin,
that
you want to
can-
introduce yourself, and then both of y'all are on the record.
Hi, I'm Devin Peterson,
how do you spell Devin?
Devyn,
Thank you.
and Peterson is SEN.
SEN, thank you.
You're welcome.
With an O.
Yes.
Go ahead, Ms. Peterson.
So the rooms, everything at our venue is ADA compliant. We currently have 3 porta potties, 1 ADA and 2 standard off of the parking lot. If you're looking at the plot map, there's a large white rectangle to the right of the black dots. Yes, so there are
Temporary food truck parking?
the truck parking is in the back of the parking lot now. So the porta
Okay.
potties are right off of the main walkway next to handicap parking, just to make sure that anybody in a wheelchair can access the restrooms. And we have these portable toilets there until we can have the permanent restrooms built.
Okay, thank you.
Yeah.
So those, hang on, let me finish my note before I go on with another. You're only going to use those until the dressing building with additional restrooms is built, is that correct?
Correct, yes.
Okay. What is the area between the barn and the dressing, and how is that surfaced? That's not.
That area is a back patio. There's string lights over the top of it, and that is used for ceremonies, receptions, dancing. It's open to what the client wants to use it for, but it is just a large 40-foot by 60-foot concrete pad.
Okay. That's between. And again, I'm just writing a note.
Thank you.
With these online hearings, I always wonder if people wonder what's happening, if we've lost me.
It does make you look up for a second to see what you're doing. Make sure we didn't lose you.
And Mr. Hall, then if that's a dancing area, then I want to know noise issues there as well. Yeah, you can address those in the open record.
Got
Just wanted to raise that issue while we're here. Ms. Dalton or Ms. Peterson, where it says
Can I-
temporary food truck parking, there's a bunch of black dots. Are those trees?
Yes,
Okay,
Yes.
just wanted to know what they were. And then it says CONT-store. Is those container storage?
those are 2 containers,
Okay.
and those block the noise going east across Beaver Creek. And we also have them there to block the parking lot so that no cars can drive into the turf area where the trees are. It's just a kind of block and a safety thing so that cars can't drive up that way.
Okay.
And noise.
I'm mostly trying to make sure I understand what I'm looking at, so I can, if I want to refer to some area, I can refer to, container storage. It's north of
Yeah.
there, south of there, whatever.
Yeah, it makes sense.
And I dropped my paper. Okay, we addressed that. Talked about the building elevations. Okay. Appears to be my questions regarding the site plan, and I think for the applicant and Mr. Hall, do you have anything else you want to add?
nothing else to add. And of course, we'll reserve time for rebuttal.
Okay, thank you.
And then ask for open record period, and we can talk about
That was I assumed you would, and we can just address that at the end as far as how much time and scheduling, etc. Okay, thank you. Is there anyone else who'd like to testify in support of this application? If so, please click on the raise your hand button. And I am not seeing anybody. Who would like to go first? If anybody wants to testify I have a panelist that has a raised hand. Christina Michini. I hope I'm saying that right.
Hi. Can you guys hear me?
Yep, thank you.
Hi.
Hi.
Hi. I'm a neighbor across Beaver Creek
Can you
Road.
state your name and address for the record
Ah.
first, please?
My name is Christina Menchini, and my address is 18232 South Valley Vista Road.
Okay.
I run Campfire Farms, a working livestock farm across the road. Our area is really interesting, especially with rolling hills and valleys. And I just want to say that, like, I am testifying to my experience, and not negating anybody else's experience. That I've put up a barn. I joined late. I'm sorry about that. But really interested in the building use conversation there. I'm running a farm. It is nearly impossible to make a living farming here. And so I'm fully in support of being able to do on-farm events and interested in the agritourism element of things. I've never heard Sage and Social's music. We can see their property from our house. So I can testify that, at least, I don't know if it's the rolling hills or the containers that they've put up, but it does not bother us. Again, like I said, that's just our experience, and there may be other people on the road who have a vastly different experience from that. But I wanted to make sure that there were a variety of voices being heard. Yeah, and that, I don't know, if our farming enterprise doesn't work, I'd love to be able to use our barn for an event space. And it's nice to have somebody who's got catering going on and to potentially be a meat provider and work in the community, to have another business that could potentially be an ally in our field.
Thank you, Ms. Mancini.
You're welcome. Thank you.
Thank you.
Anybody else? And Ms. Mancini, if you'd click on the raise your hand button, so that goes there. Thank you. Oh, nope, it didn't go away yet.
Yeah.
And Candy with a raised hand, Julie Harrison, and you're muted. You'll need to unmute yourself. There you go.
This
Ms.
whole process is very new to me, so bear with me.
No problem. This, especially the online process, is new to everyone. So,
Right.
or
My name is Julianne Harrison,
is it Julianne separate words or as one?
separate.
Okay, thank you. Just want to make sure I get it right. Go ahead.
And I live at 29245 South Beaver Creek Road, New Lino, Oregon, 97042. So I am directly next door to these, to the Daltons.
Okay, if I'm standing on Beaver Creek Road facing this property, are you left or right?
To the right.
Okay, thank you. That helped me. So you're kind of to the east, general.
Right. And this property was part of my property up until 4 or 5 years ago.
Okay.
I agree with what Christina has said. To me, it's a joy to see these people working so hard and bringing their venue to the area. I think they've added a lot of enrichment. They have been totally respectable and wonderful neighbors. I have not experienced, I watched in the beginning to see if traffic was a problem. I never witnessed anything that was. The noise does not interfere with anything I do at all. And the lighting has been, I'm a little higher than they are ground-wise. So the lighting has never been a problem. I'm just totally in support of them.
Okay. Thank you, Ms. Harrison.
Thank you.
Anybody else who'd like to testify in support?
We do have we have a neighbor across the street that's trying to jump on the call, but she's saying it's kicking her out. So I don't know.
You will need to use the public link. She can't use your link.
No.
She needs to go through the website and use the public link.
Okay,
Thank you.
that's what she's having.
No,
Thank you.
We'll come back to her when she gets logged on. But in the meantime, I'll go ahead and take testimony in opposition. Who'd like to go first to testify in opposition or with questions or concerns? And can you mute yourselves, the applicant mute yourself, because I think we just got some feedback issue. Is anybody who'd like to testify in opposition or with questions or concerns about this application? If so, there we go. One raised hand from Malia. I don't have a last name. You're muted at the moment.
Yes,
There you
I am
go.
now unmuted.
Yep,
I
we can
am-
hear you now.
I am Malia Capillas. I live at 18487 South Valley Vista Road, Malino, Oregon.
Thank you.
And
Can
I
you
was
spell
the-
your last name for me?
Sure, it's Kupillas.
Kutillas.
Capillas, Kup as in Peter.
P, thank you. Thank you. That's when you said that, as soon as I wrote the P, I recognized it from the written testimony. Thank you, Ms. Capillas.
Okay, you're welcome. I was the one who took those photos in Exhibit 11.
So
And
you're roughly west of the site, is that correct?
well, here's the issue. Our horses
Oh,
live
right.
all summer long on the property directly west from them. And so, you know, during the day and the evening when we have to run up and care for them, if we noticed that there was an event going on, then I would take photos. And I can assure you that I made sure that never, ever was one of those photos ever taken from the property line or from the Dalton's property. There's fence posts, so I can clearly see it from the property to the west, and it's thoroughly fenced from the south. And I stood on the county property next to Beaver Creek Road to take the pictures and also to do the sound readings. And to answer his, and if you want better references on the property to the west, I took the photos from that stretch where there are no trees. There's actually a gap in the trees. And when I took sound readings from a variety of places, starting with where our horses were. And the one that I submitted for the record was taken standing next to Beaver Creek Road at the south side of the property.
Okay.
And I made sure when I saved one that there were no cars or anything else driving by adding additional sound to it. So that is strictly the sound from the property. And one of the things that we did observe was that as the parties progressed, the volume increased until right before quitting. And I'd also like to note that we actually live 1,120 feet away from the event center off Valley Vista Road. And at night, when we'd be trying to go to bed at 9:30, we could still hear the events. Yes, it would, because of the way the hills and everything curves. Yes, we could stand there in our bathroom because we don't have air conditioning. So our windows are open, and we could listen to the event music and notice when it actually quit. Let's see. What else did I want to say? So, you know, the reality is, and depending upon where you are and the direction the sound travels, the trees, in some cases, do not provide the attenuation that they are hoping for.
Thank you, Ms. Capillas. If you click on the raise your hand button, we'll know you're.
Yeah, and I'm still.
Go ahead. If you had more to say, you're muted now. There you go. Thank you, Ms. Capillas. Is there anybody else who'd like to say anything about this application? I'm just pausing. Okay, Jennifer Racine. And well, before Ms. Racine starts testifying, if anybody else wants to say something, please go ahead and click on the raise your hand. We'll get to you next. We'll just go through the list. I see Ms. Capillas has raised her hand again. We'll come back to you in a minute because we have Ms. Racine unmuted now. Go ahead, Ms. Racine. Can you state your name and address?
This is Lonnie Hester.
Okay.
18022 South Valley Vista Road.
Thank you. Go ahead, Mr. Hester.
Yes, you can hear the music quite loud from our property. And I don't know if it's the topography, just the way the land's shaped, but it's very loud on our property. We're the first property as you come onto Valley Vista on the right.
And where is, I don't have the area map up. Where is Valley Vista in relation to the site to the east, west, north, south?
What would be just south, just down the hill from their property, the next driveway down?
Is it, what's the name of the street? Valley Vista Road, Street Lane?
Valley Vista Road.
Thank you. Makes it easier to find. So just to make sure I understand what you just said, you're on, your residence is on Valley Vista Road, some distance south of the site, and you can hear the sounds from the events on the site, correct?
Oh,
Okay. Anything else you wanted to add, Mr. Racine? I'm sorry. I'm looking at my screen, Mr. Hester.
mainly just a traffic concern. We've had 37 accidents on that corner since the lifetime of us living here, and just cars turning
Which
around on
corner?
Valley Vista Road.
Valley Vista and Beaver Creek?
Yes.
Okay.
So other than noise complaints and traffic control, that's our only concern.
Okay. And 37 accidents over what period, roughly?
About 12 years.
Okay. Thank you, sir. And if you want to click on the raise your hand again, we'll go away. Ms. Capillas, did you have something else you wanted to say? Didn't mean to cut you off back there.
Okay.
Hi, yeah, actually, no, this is Greg Capillas. I'm actually sitting here with Malia. I would also like to say something here.
And I assume your address is the same?
Greg Capillas, same spelling, 18487 South Valley Vista Road. Yes.
Yes, sir.
And anyway, yeah, I mean, I too have concerns about the noise. You know, I have experienced the same issue that Malia described, you know, sitting in our house in the evening, you know, hearing the noise kind of blaring from the event. And, you know, I think there is definitely a potential for that to, you know, sort of interfere with our enjoyment of our property. I guess just another thing I would like to say, you know, some of the other neighbors or those that are, you know, have testified in favor have talked about how the applicants have, you know, been good neighbors and, you know, really, you know, complied with the rules, or there's been testimony about how they really wanted to comply with the rules. But, you know, I guess I'm concerned because of the way that they have, you know, basically flagrantly flouted the law throughout the whole summer, holding events, you know, without a permit to operate. I guess one of my biggest concerns, you know, is, you know, what assurance do we have, you know, based on, you know, what they've already done, based on their violation of the rules so far? What assurance do we have that they're going to comply with the rules if they're, you know, given, if they're allowed to do this?
Okay.
That's my biggest concern. Thank you.
And if you can click on the raise your hand button again, is there anybody else who's not had the chance to testify who'd like to say anything about this application? Did the applicant's neighbors able to log on? You know? Question for the applicants themselves. If you're talking, you're muted. So I don't know if you've heard from your neighbors if they were able to log on. But I am going to hold the record open if they want to submit something in writing if they're unable to log on. And the applicants were not hearing you yet. You may be muted still.
Oh,
there we go. Now we hear you. Now we hear you.
Mr. Early just logged on. I just saw his face and now he's
okay.
But we have Mr. Early and we've got our neighbor directly across the street. They look like they're both having trouble joining, so
They
we might
need
want
to, they need to use the link that is on the web page.
Yeah,
The
mine
county's
was
webpage.
he was just on here, so I don't know if he accidentally pressed a button.
You just broke up. We lost your. You're breaking up a little, and then we lost your audio.
We've got two more people that Can you hear me?
Losing your audio. I understand you have two more neighbors you want to testify. You might shut off your video and your audio would come through better. It'd reduce the bandwidth. But I understand you have two people you want to testify. I think I'm going to have Mr. Hall respond, since these are supporters. If they are able to get on, we'll let him testify after Mr. Hall. He can wrap up after that if he chooses to, if he needs to. If they're unable to get on, they can submit something in writing, because I am going to hold the record open. So we'll get their testimony one way or another. Mr.
Great.
Hall, thank you.
All right. Thank you, Hearings Officer Turner. Sorry for the difficulties there in the communications, and appreciate the flexibility, and hopefully these folks can find a way to connect here.
You're not the first one to have issues with the technology.
Yeah, it's always something. And
Mhm.
so wanted to just, touch on a couple of points that were made here. I think in the testimony that was supportive, I think an important part of it is really looking at, again, to what is the policy that the state's intending to, with its regulation of use on rural lands. And I think it's Miss Mancini made a very good point about how on-site revenue can help the the sustainability of a farming operation, especially in lands where it might be somewhat hilly, and the parcels aren't large tracts as some would think, to do industrial scale farming and all that type of stuff. So having an operation where you can hold events and you can utilize local products and work with your neighbors and use the things that are grown actually in the area, for catering and events, and help sustain the agricultural economy in the immediate area, I think is really kind of along the lines of a policy that we could identify as this application for furthering. And why am I talking about policy? Again, because we really kind of only have a disagreement about one approval criteria, and everyone says, you can interpret it how you want, but nobody, neither us nor the county, seem to have been able to identify a reasonable policy that would align with never being able to improve a building for a use that's allowed. So I think some of the questions about impacts, we'll get you some responses. We understand that some of the neighbors are able to hear the music. We want to go back, circle up, figure out what we can propose to ensure that there's as much sound attenuation as possible, demonstrate that we are in compliance with and feasible to comply with the decibel reading standards at the property line. And then have conversations with our neighbors about, hey, let's work together and figure out the best way to ensure that we can have events in the area, and that they can have their lives, live their lives in a unimpeded way. And we know that there are some standards related to that, so we're glad to demonstrate compliance in the open record period to those. I think we've got some of the the counterpoint evidence as far as decibel readings and going out and that type of thing, and we'll submit those. But it really isn't about, well, the land use attorneys care about, like, what is the decibel point reading at the property boundary, and we will get over that hurdle as far as substantial evidence in the record. However, speaking for Devin and Stacy, what they care about is being good neighbors and being able to pursue their business. And I think that it is business that's allowed in the zone, and they're looking to do it responsibly and comply with all the standards. Again, I think there's a element of what does the state law mean, and we're trying to figure out ways to intelligently respond to that and have it not be some trap. But I think with what we've proposed, and utilizing the barn is a great way to go, and we'll get you, and know that I hear you loud and clear, here's Officer Turner, that we'll get you the granular data you need about different configurations and when the doors are up versus not, and what are the specific distances and decibel readings and things along those lines. So glad to go and do that work in the open record. And then I'm seeing also Devin, but you're kind of still glitching a little bit. Just a heads up. Go ahead.
Can you hear me okay?
Yep.
Okay. I just wanted to make one comment about.
Can I get your name again? I'm not sure who's who. I'm sorry.
Yeah, Devin Peterson.
Thank you.
You're welcome. I just wanted to make a comment about the music. You had mentioned something about music having to be off by 10 and how we're taking care of that happening. So we talk to every DJ that comes on site, and every DJ and wedding planner knows that last dance is at 9:50. That way the last song is done by 9:55 at the latest, and music is off by no later than 10. And all of our decibel readings have photos of exactly where we're taking them. We also have video. That way you can see the decibel reading will go up if you're talking as you're taking the reading. So it could go up to 80 just because I'm sitting here having a conversation recording it. Our recordings have the music showing where exactly we're at, not talking, and we're not even close to the property line, not getting over 60. So we're happy to provide those videos so that you can see.
Thank you.
You're welcome.
Mike had his hand raised. And I'm assuming that's one of your neighbors that you wanted to testify and support. Mike, I don't have your last name, but did you still want to testify? If so, please click on the raise your hand button again. We did see you. I just didn't get a chance to get back to you yet. There we go. You're muted. You'll need to unmute yourself. And can you state your name and mailing address?
Mike Early, 18362 South Valley Vista Road, Oregon, 97042.
Thank you, Mr. Early. Is it EARLY?
Affirmative.
Thank you. Go ahead, Mr. Early.
I am perhaps an eighth of a mile straight line distance from the Dalton property in question. There have been no events that I could hear outside of one sometime several months ago, and that was when the wind was gently out of the west and carrying the sound to us. Their property has not been a difficulty for us in any respect whatsoever. I do not believe that the Beaver Creek Road traffic that event center might generate to be a problem. There's plenty of traffic on the highway, regardless of whether they're there or not. I would also like to state that their use of their property, in my estimation, could be allowed, subject to the appropriate code violations or whatever might be appropriate to the circumstance. I have no objection whatsoever to them having their business or having their event center, using it the way they choose to use it. That would be the end of my statement.
Thank you.
Thank you.
Mr. Hall, anything you want to add? I want to make sure you get the final word, but if not, that's fine.
Nothing's in particular to add other than, you've heard from a number of neighbors here, and we'll lay out. They've given you their addresses and talked about where they live. We'll lay out exactly where it is. We think that some of the folks that are the closest and have the least amount of screening and buffering aren't on the other side of forests, aren't the majority of a mile away. Are some of the folks that are the support on the sporting side here. So wanted to point that out, and glad to wrap things up and transition to a discussion of open record.
Yeah, how long would you like initially to submit new evidence?
I think we can move pretty quickly, but I'm looking at Melissa.
The holiday is going to cause some issues, I assume.
Yeah, there's a holiday, and we also just gave the staff new information about the alternative site, and the one event per week over the course of the year type thing. So I want to make sure we're not precluding the opportunity for the county to weigh in on what we've given you. So I think get a couple weeks, get to the other side of the holidays.
Yeah, I'm not in any rush. We've got plenty of time on a 150-day clock, and the more information I have, the easier my decision is from all parties. So
yeah, I would say, so Mel, how much time are you thinking? Are you like 2 weeks for the first open record period or?
I think that's fine. I would be happy with 2 weeks.
Okay. Hearings Officer Turner, this is Lindsay Nesbitt, Planning Manager. Would it be okay if Mel and I just clarify one thing that I
Sure.
spoke to earlier? Okay, so earlier I said that, or implied that our county council worked with the building official to determine that ag buildings could not be converted. That is incorrect. They independently made that determination. So county council made the determination upon reviewing the Oregon revised statutes. And Mel, your understanding is that our building official reached out to the state building official?
Yeah, that's correct.
And the state building official also determined, but we don't have that in a memo.
Okay, just to make sure I understand, I'm going to say back what I understood. Your county council didn't confer with the building official, is that correct? The state building
With the
official?
state building official, correct.
They just determined that the interpretation the county's going with it can't be converted back to a non-ag use on their own. And the state building official came to that same conclusion independently. Yes.
Mel, the second part is that your understanding of the conversation with our building official?
Yeah, it is.
Okay. And there's the state building official and there's the county building official, is that correct?
Correct.
And who said what? Did the state building official involved it? Did they come to the same conclusion, or was it the county building official?
Well, it sounds like we have some follow-up that we need to do just to make sure that
Okay.
we've got our story straight. There's no
Yeah.
written memo for any of this. My understanding is that the Clackamas County building official reached out to the state of Oregon building official, verifying what in fact that ORS provision meant, and they in turn confirmed, yes, it means you cannot convert the use of this building.
Okay. If they want to weigh in writing, I would love to see something, county council or state county building official. Anybody wants to weigh in on that issue. More information I have, the easier it is sometimes.
Thank you for letting us clarify.
No,
my
I appreciate the
misstatement.
clarification.
Appreciate it. And then, so Mel, 2 weeks, is that what you think with your current workload?
That's fine.
So what I would generally do is hold it on for a period, sounds like 2 weeks to start with, for everybody to submit new evidence, a second period for everybody to respond to the new evidence, and a final period for the applicant's closing argument with no additional evidence. Does that work for county and applicant? And
Yeah, so 2-1-1 as far as
that's great with me.
Works for me.
The first 2 weeks would be the 28th, 3 days after Christmas. That's not an issue for anybody. Good. Okay. With that, I will close the hearing. I will hold the record open for 2 weeks to start with until December 28th at 4 p.m. Anything anybody wants to submit has to be physically received by the county. You can send it to Ms. Lord via email, regular mail, or delivery, but however you get it there, it has to be physically received by the county by 4 p.m. on the 28th of December. I will hold it open for an additional week. All right, got to switch years on my calendar. Until January 4th of 2024 at 4 p.m. for anybody to respond to whatever was submitted during that first 2 week period. So the second open record period is limited to responses to what was submitted during the first period. And then a final week until January 11th. Yeah, talking right at the same time. Of 2024 at 4 o'clock for the applicant's final argument with no new evidence. And that third period on the 11th is limited to the applicant alone. I will issue my written decision within 2 weeks after that, which would be the 25th of January. As I noted, I'll send my decision to the county. The county will send it to parties of record. And so if you testified orally or in writing already, or if you do so during the open record period, you'll be sure and receive a copy of my decision when it's issued. If you haven't testified, don't choose to do so during the open record, you can ask for a copy from staff. That concludes our hearing. Thank you all. Have a good afternoon and happy holidays.
Thank you. Take care, folks. Happy holidays.